afternoon, everyone. Thank you all for joining us today for this lecture on domestic and international arbitration. This lecture series has been organized by Prudentia Partners, L.I.K.E, Legal Information, Knowledge and Expression, in association with Center for Research in International and Comparative Law, MLNU Aurangabad. And Legitquest is the knowledge partner, along with LegitEye as the media partner. Prudentia Partners, founded in 2016, is one of the fastest growing law firms in Delhi, equipped with very versatile team of attorneys dedicated to provide best service in wide range of legal services across various sectors such as civil, criminal, matrimonial, electricity, telecom, environmental, banking, and commercial litigation. L.I.K.E is an online one-stop legal solution for all the updates of the legal world, with the goal to provide a platform to others budding brightest legal minds and ignite the culture of debate and deliberation across the legal fraternity. Maharashtra National Law University, Aurangabad is an institution established in the year 2017 with an objective of imparting quality legal education. Legitquest is an artificial intelligence-based legal research product. It is a state-of-the-art legal research platform for conducting legal research and is a very well known for the introduction of the world's only one-click insight system called the iDraft. In short, iDraft feature powered by artificial intelligence takes out the issue, facts, arguments, reasoning, and decision of case law. Legitquest has recently also started with LegitEye, which has the latest news, interviews, and columns, and serves as the stakeholders of judiciary. Today's topic for today's online lecture series is interim relief under Section 9 and 17 of Arbitration and Conciliation Act, which will be taken by Mr. Vikram sir. Mr. Vikram sir practices in the field of land acquisition, arbitration, intellectual property rights, insolvency and bankruptcy law, service law, against sexual harassment, consumer protection law, and real estate law. His fora of practice includes the Supreme Court of India, Delhi High Court, district courts in Delhi, NCLT, NCLAT, NCR, NCDCRCs. So before start, let me brief you all that today's session will be for 45 minutes, followed by the question and answers. I would humbly request all our participants to please be on mute and without video throughout the call, and all questions to the speakers can be written in the chat box, which will be taken at the end of the session. So we seem to be all set. I would now hand over it to Mr. Aishwary sir. Thank you so much.
Thank you so much, Soumya, for that introduction. Now, can you just upload the slides if possible so that I can start with the session?
Sure, sir.
Yeah, it's here. Just in the PowerPoint or slideshow mode.
Sir, is it visible now?
Yeah, it is visible. Just you need to put in the slideshow mode so that it's bigger. The slideshow mode you will find in the bottom right. Yeah.
Sir, now it is?
Yeah, absolutely. Just go to the next slide, please. But I think you can keep yourself on mute.
Sir, on the slideshow mode, it is
Okay, don't worry.
system.
I'm just forwarding the slides to.
No, no, sir. In my laptop, it is not functioning properly.
Yeah, I understand. That's okay. Now, this is the first slide. I think we should begin. Slideshow can be done later. So, today, the topic which was left over from yesterday that I did not deal in the earlier lectures properly was disputes that are inherently non-arbitrable. That's one. And after we finish this part, we will go to the next aspect that will be on Section 9 and Section 17 of the Arbitration Act that relates to interim reliefs that can be granted by court and by arbitrators respectively. Now, what I have told you earlier is that there are certain disputes that are non-arbitrable in nature. The reason for this is that arbitration as a practice and arbitration law has evolved disputes that are rights in personam, meaning thereby that it is limited to the persons who are submitting the dispute and does not affect the whole world at large. Whereas rights which are right in rem are non-arbitrable in nature. The reason is that you can't bind a person who is a third party by an act which is private in nature by award of the arbitrator. That's reason number one. Reason number two is that there are few specialized bodies in the form of tribunals or courts which have been given the jurisdiction to decide a particular dispute. We can take the example of the Delhi Rent Control Act. Now, under the Delhi Rent Control Act, a particular tribunal and court which is established to decide matters relating to landlords and tenants. Now, when these particular courts are created and have been given the jurisdiction, the legislature as well as the courts have thought it fit that it is for them to decide and not for the arbitrators to decide such type of disputes. The third reason that I have told you that many a times it so happens that it's a form of a document which gives a right to a beneficiary and the beneficiary is not a signatory of that particular document. For example, trusts. Now, trusts usually are made by a person to his trustees and benefit and for the protection of his beneficiaries. Now, beneficiaries and trustees may or may not be a party of the trust document, and because of this reason, it sometimes becomes hard uh, to enforce even an arbitral award, if so given, upon parties who are not signatory to the arbitration agreement. Precisely because of these three reasons, which are the major reasons, that the courts have created a distinction between disputes that are arbitrable and disputes that are not arbitrable. Now, let's first understand what are the three conceptions of arbitrability. The first is that the dispute capable of being adjudicated through arbitration, meaning thereby this is the primary thing which we are going to discuss today. That what are the form of disputes that are non-arbitrable in nature. Apart from that, if there is any other dispute which is commercial in nature, or even though if it may not be commercial in nature but is related to the contract, then it is arbitrable. Second, then we are going to cover disputes covered by the arbitration agreement. Now, it may so happen that try to visualize it in your head that the ambit of disputes that are arbitrable in nature is very large, right? But the arbitration agreement may limit the jurisdiction of arbitrator to certain type of disputes. If there's a limit of the arbitrator on certain types of dispute, then out of that bigger wide angle of arbitrability of disputes, few disputes will be taken which will be in consonance with the arbitration agreement. Then third thing is disputes that the parties have referred to arbitration. Now, it may so happen that the arbitration agreement is wide. It may carry about many other form of disputes, but the statement of claim that has been filed by the parties may allege three or four types of disputes. Supposedly, let's take an example that a loss was caused to you, and the loss you have adjudicated is rupee 100. Now, if you want to refer it to arbitration, there may be various heads under which you may claim your losses. Supposedly, you give away few type of reliefs in your statement of claim. Then the arbitrator cannot grant those reliefs because it was never claimed. That is why it is the bigger circle, or the biggest circle is arbitrability itself, as to which disputes are arbitrable in nature. The smaller circle inside that bigger circle is what form of disputes have been submitted to the arbitrator to be decided by the arbitration agreement. And the third and the smallest one is what are the claims out of those particular disputes that have been submitted for arbitration before the arbitral tribunal. These are the three concepts that one should understand. Then we come to disputes according to Booz Allen's judgment, which is a landmark and still followed. What type of disputes are non-arbitrable inherently and cannot be arbitrated even by the consent of the parties or by the arbitration agreement? The first is disputes relating to rights and liabilities which give rise to or arise out of criminal offenses. Now, supposedly there's a dispute which leads to a criminal offense, or the criminal offense was itself a form of dispute submitted by the parties, then it is non-arbitrable. Because for criminal offenses, there are criminal courts, there's a completely different structure of the judiciary to deal with such type of matters, and hence it cannot be given for arbitration. Second is matrimonial disputes, such as divorce, judicial separation, restitution of conjugal rights, and child custody. If you see, all these three particular aspects also affect third parties, and there's courts to decide such type of disputes under particular acts, and therefore this is also made non-arbitrable. Guardianship matters. Now, guardianship matter is something which not only affects a child, for whom the person is appointed as a guardian, but also excludes the right of other third parties from being appointed as a guardian. And because it is affecting the third party, and the court feels that it is not in public policy to allow it to be arbitrable, therefore this is also excluded. Insolvency and winding up matters. Now, I try to understand, insolvency and winding up matters are rights in rem, meaning thereby that any person who is affected can approach the court for declaring a particular company insolvent or winding up, or being wound up. So these people are indeterminate, meaning thereby that their numbers cannot be determined. They can't be put and sign a particular arbitration agreement to refer these such type of disputes to arbitration. It will become very difficult. And precisely because of this reason, insolvency and winding up matters are also non-arbitrable. Then are testamentary matters. Again, testamentary matters also affect the rights of third parties. They may not be part of the arbitration, and they won't want the award to bind them, and that's why this particular section is excluded. The last is very important because there has been a recent Supreme Court judgment on this point explaining this very aspect. That is, eviction or tenancy matters governed by special statutes where the tenant enjoys statutory protection against eviction, and only that specified court are conferred jurisdiction to grant eviction or decide the dispute. Now, this is very important because it has led to some uncertainty whether a lease, dispute relating to a lease is arbitrable or not. Now, I'll tell you why this is important, because recently the Supreme Court in Himagni Enterprises versus Kavaljit Singh Aluwalia said that lease, being a part of Transfer of Property Act, will not be arbitrated. Now, recently in 2019, Justice Roynton has examined this particular aspect, wherein the facts were that there was a particular arbitration clause under a lease agreement. The question was whether leases fall within the exempted category that is provided by Booz Allen, whether leases are arbitrable or they cannot be arbitrated upon. Now, in Vidya Dolia, the court said that, see, Booz Allen is very clear. Booz Allen says eviction or tenancy matters governed by special statutes, meaning thereby that such eviction or tenancy matters have to be statutory tenancies. One of the example is Delhi Rent Control Act. Other can be Uttar Pradesh Rent Control Act. Various states have their own rent control legislations. These legislations are made to protect the tenant and also provide some grounds for evicting the tenant to the landlord. And precisely because of this reason, this being created by special statutes, and there are specific courts to decide such type of disputes. And that is precisely the reason statutory tenancies are kept outside the domain of arbitrability. Now, the point then the judge tries to emphasize is that leases are not statutory in nature. It may be that the leases are contractual in nature, meaning thereby that supposedly I stay in Delhi, I have my own house, through a contract, I have allowed a person to live or to conduct his business in my premises, then my relation with that particular person will be dependent upon the lease agreement. It won't be dependent upon the protections that is being provided under the statute. And precisely because of this reason, the court says that leases are arbitrable, but statutory leases are not. Means the court created a distinction between contractual tenancies and statutory tenancies. Now, I must also point you out this that because both, I think Himagini was judgment given by a bigger bench. So, in Vidya Dolia case, Justice Roington has referred this matter, and now the matter is pending before a bigger bench to be decided upon. However, it is law at the present that even a referral order of the court is binding upon the other courts, and they are free to decide which law they want to apply. So let's see what the Supreme Court now decides on this issue, whether the leases are arbitrable in nature or not. Next slide, please. Okay. Now, another aspect, first aspect that I have dealt is whether leases are arbitrable or not. Now we come to the arbitrability of fraud. Now, in Ayyaswamy case, which is a Supreme Court judgment in 2016, the court was of the opinion that fraud simpliciter is arbitrable. But a serious question of fraud will be non arbitrable, which invalidates the very existence of the agreement. Now, it was not clear as to what is a serious question of fraud. Later, in 2019, Rashid Raza versus Akhtar, this related to a partnership dispute wherein there was some siphoning of funds which was committed in the business, and an FIR was also lodged. Now, the question was whether, in view of the fact that an FIR has been lodged against a particular person, can the disputes now be referred to arbitration? To this, the court said that yes, the disputes can be referred to arbitration and there's no problem with it, because this very FIR that has been filed relates to siphoning of funds or various other business improprieties. But this does not affect the validity of the arbitration agreement itself. It does not go to the roots of the arbitration agreement, pointing it out to be non existent. And therefore, the court said that such disputes are arbitrable, even though there may be one of the angles that relates to siphoning of funds or improprieties. This alone cannot make the agreement non-arbitrable. The FIR may go on, charge sheet may be filed, criminal proceeding may continue, and this being a form of a civil dispute which alleges siphoning of money, and to establish that fact, the arbitration can be conducted. Then we come to a very recent again of 2020, that is Avital Post Studios versus HSB. This judgment is also of Justice Roington. Now, in this particular judgment, Justice Roington points and explains the two tests that he laid in Rashid Raza's case. The first test was, do these pleas permeate to the entire agreement or above all the agreement of arbitration, rendering it void? And the second was whether the allegation of fraud touches upon the internal affairs of the parties inter se having no implication to the public domain. These were the two cases in which the disputes could have been referred to arbitration. Now, what the court has explained, these two particular tests, the court has explained that fraud per se does not make a particular arbitration agreement void. If you recall the Indian Contract Act, if a consent is taken by fraud, it makes it voidable and not void. This is precisely the reason given by the Supreme Court, saying that fraud per se cannot affect the arbitration agreement. It has to be shown that there was no arbitration agreement at all, or the parties never entered into an arbitration agreement. These are the requirements that have to be shown under law. Now, the second thing is that the court also says that where the fraud, arbitrariness, or malafide conduct relates to a state instrument or instrumentalities, in that case only, if it is alleged that the arbitration agreement is affected by fraud, then the court will not refer the matter to arbitration. So this is the whole law on arbitrability of fraud, which I may again summarize, that fraud simpliciter is arbitrable, but fraud which is serious in nature, which fulfills the two ingredients, that is, that it affects the very existence of the arbitration agreement, or and it relates to malafide, fraud, or arbitrariness against the state or its instrumentalities, then only the court will not refer such matter to arbitration. Next slide, please. Now, now let's come to the main topic for today, which we were going to discuss. That is Section 9 and Section 17 of the Arbitration Act. First, start with Section 9. Now, if you see this particular part, though Section 9 already existed, but it was amended in the year 2016, in the year 2016 by Act 3, which was in effect from 2015, 23rd October. The law has been amended to some extent relating to Section 9. Now, what the present Section 9 says is that a party may before or during arbitration proceeding or at time after the making of the arbitral award. So see, there are three things: before, during the arbitral proceedings, or at any time of the making of the award, but before the enforcement of the award. So, before the arbitration proceedings have started, during the arbitration proceedings, and the third is after the award is made, but before its enforcement. In such three cases, the court can grant interim relief. Now, what will be the form of interim relief that is provided thereunder from subclause Roman I2, and then A, B, C, D, E. Now, for appointment of a guardian for a minor or a person of unsound mind for the purposes of arbitration proceeding, which is not very much applicable, and usually in most of the cases, this is not the issue. It is usually the second one. For an interim measure of protection in respect of any of the following matters. Now, what are these matters? This part is very relevant because in most arbitration where interim relief is sought, such things happen and such particular interim reliefs are claimed by the parties. First is the preservation, interim custody, or the sale of any goods which are subject matter of the arbitration agreement. Second is securing the amount in dispute in the arbitration. Now, I have marked this in bold letters for the simple reason that there is law on this as to what tests the court should apply, whether the court should apply the principles of CPC while deciding this particular criteria ingredient, that we will discuss later. But for the time being, just remember securing the amount in dispute in the arbitration. Third, the detention, preservation, or inspection of any property or thing, right? Fourth, interim injunction or the appointment of a receiver, right? Then E, such other interim measures of protection as may appear to the court to be just and convenient. Why was this required? This was required because you can't, every fact is every case will have different facts, right? It can't be a straight jacketed formula that you apply particular criteria to each and every case, irrespective of the difference that may be there in the facts. Precisely because of this reason, the courts have now been given the flexibility, not now, it was also there earlier, have been given the flexibility to decide what form of interim protection can be given, which will be in the interest of justice. Now, subclause 2. When, before the commencement of the arbitration proceeding, a court passes an order for an interim measure of protection under subclause 1, the arbitral proceeding shall be commenced within a period of 90 days from the date of such order or within such further time as the court may determine. So this is just to bring efficiency into the system of arbitration so that interim measure is not enjoyed by the party and the other party is not at detriment for time immemorial, but the arbitral tribunal should be constituted ASAP so that they can decide whether the interim relief that has been granted should be continued further or should be declined. The last is, once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that the circumstances exist which may not render the remedy provided under section 17 efficacious. Therefore, what does this mean is that this particular provision was added by the 2016 amendment, which was effective from 2015, just in order to put some restrictions on the power of the court to grant interim relief, because in the very same amendment, Section 17 was also amended, and Section 17 powers of the arbitral tribunal were made in consonance with what is provided under Section 9 for the courts. And this is precisely the reason the third clause was added so that the courts don't grant interim relief, which could easily be granted by the arbitral tribunal, or during the proceedings of the arbitration, if an arbitral tribunal can grant a relief under section 17, why should a court interfere and grant such similar reliefs? It should be the arbitrator who should grant it. And to club such type of interferences by the court, subclause 3 was provided. Next slide, please. Now, yesterday, a a good question was asked as to where Section 9 is maintainable. Now, if you see the definition of a court under Section 2E, which will have the jurisdiction, you will find that in cases of arbitration other than commercial arbitration, civil courts of original jurisdiction in a district and a high court in exercise of its original civil jurisdiction will have the jurisdiction as far as arbitration other than international commercial arbitrations are concerned. But in international commercial arbitration, it will be only the High Court in its original ordinary original civil jurisdiction which will have the power to grant Section 9 reliefs and where the petition for Section 9 can be filed. Now, there can be two scenarios in domestic arbitration. Supposedly, a seat has been fixed by the parties under the arbitration agreement. Then what will happen? In such case, if a seat is fixed, then because as I have told you earlier, that fixation of seats helps in order to decide which court will have supervisory jurisdiction, right? So the court which has supervisory jurisdiction on that particular seat selected by the parties, that court will only have the power to grant interim relief, right? Second, supposedly the parties have not selected a particular seat and the arbitral tribunal is yet to be constituted and the arbitral tribunal is yet to decide under section 20 subclause 2 as to what will be the seat of arbitration. In such case, the parties can apply to a court where part of the cause of action has taken place. meaning thereby the courts which ordinarily would have jurisdiction if it would have been a civil matter, the same courts can be approached. But that is only when the seat for arbitration is not fixed by the parties. And if you read Section 42 of the Arbitration Act, it makes it very clear that once you approach a particular court for a particular relief, then you have to make all applications to that particular court only, right? Now, let's see in the context of foreign arbitrations. Now, I was telling you yesterday that in foreign arbitration, the seat is usually outside India, meaning thereby that the supervisory jurisdiction of the courts will be also outside India, right? So, Indian courts won't have a role to play. And that is precisely the reason that an amendment was brought wherein section 2 subclause 2 proviso now provides that section 9, section 27 and section, I think it's 37, by mistake it's written 47, 37 3 subclause 1a, the courts have held that section 9 will also apply to foreign arbitration until and unless the parties by express consent, which is expressed in the agreement, have excluded the application of part 1 of the act. Therefore, the parties, even though they are party to a foreign arbitration, can approach to the Indian courts for their enforcement. Now, when will that be? Now, supposedly, a party has an award in his favor. The properties of the party is situated supposedly in a particular place, or a party is an Indian party. Now, the other party wants to enforce that award against him, right? So when they will file for enforcement under section 47 of the Arbitration Act, then they will also can file a petition under section 9 for interim relief before the same court. So where the courts will have jurisdiction under the proviso of section 47, there only interim application under section 9 can also be filed. Next slide, please. Now, these I have told you what are the form of natures of the reliefs that can be granted, but this particular thing I'm repeating it again because they have been, what do I say? There have been an inconsistent judicial analysis on this particular section. And the issue that has always been there, which is still continuing, is whether the provisions of CPC will apply to a petition under section 9 or not, right? And I'll take you in greater details in some time. Now, if you see 9 subclause 2b says that the party can seek remedies such as securing the amount in dispute by way of bank guarantees to be furnished by the opposite party. Now, this is one of the form of reliefs that can be claimed under 9 subclause 2b. If you read the section, the particular ingredients of it, this remedy will fit, right? Second thing is 9 subclause 2c, courts can appoint a receiver, courts can allow the parties to take symbolic possession of the properties. 9(2) subclause E, to furnish list of properties, attachment order against third parties, direct parties not to dispose of their properties. Now, let's understand it in the context of CPC. If you remember, and you would all be knowing that under Order 39, Rule 1 and 2, the parties usually have to establish 3 particular ingredients. That is prima facie case, balance of convenience, and irreparable loss. Now, supposedly, all these 3 ingredients are not fulfilled in your petition. Can you then go and argue before the court, you give me a interim relief because I want it? You have to show something. What should be the criteria? How to decide whether interim reliefs can be given under Section 9? Because there's no guiding factor under Section 9, right? So the courts have now divided their opinion in 2 parts on this. The courts are divided actually on this. One is an exclusive approach, which says that the rigors of CPC, yes, the principles can apply, but the rigors of CPC will not apply to an application under Section 9 of the Arbitration Act. Second is an inclusive approach, which says that no doubt that particular principles which are provided under CPC, which are inherent, that can be very well applied to Section 9, because Section 9 cannot operate in vacuum. It has to have some reality, some existence, some form of tests that can be used by the court to exercise their discretion under Section 9 whether to grant an interim relief or not, because Section 9 as such does not have any form of tests that have to be satisfied. Precisely because of this reason, the court usually applies two things. If it is to grant an interim relief, then it usually applies the principles that are embodied under Order 39 Rule 1 and 2, which says that a party who is approaching for interim relief has to satisfy the court for three things: prima facie case, balance of convenience, and irreparable loss. What do I mean by prima facie case? The prima facie case means that if you read my petition, it will appear to you that my grievance against the other side seems to be correct if taken on face value. That is the first thing. Balance of convenience. Balance of convenience means that if you don't give me this relief, then I will be deeply affected. And even if supposedly you give me a relief, then the other side will not be affected to the extent I will be affected if no relief is given. Right? So that is balance of convenience. The third is irreparable loss. That if you don't give me this particular injunction, then I will suffer a loss which cannot be compensated in form of money. So these three aspects are in the inclusive approach which are applied by the courts in a petition seeking interim relief under Section 9. Now let's just consider a few judgments on this aspect. The first was by the Bombay High Court in Delta Construction System Limited, Hyderabad versus Narmada Cement Company. Now, this is a 2002 Bombay High Court judgment. The Bombay High Court said that, and this is one of the examples of exclusive approach. The Bombay High Court said that, see, the whole intention of the Arbitration Act is to come out of the rigors of CPC. Arbitrators are not expected to apply the CPC at all. So why there should be a requirement that the party should apply, right? First thing. Then the court said that, see, Arbitration Act is for, what do I say? Arbitration Act is for a quick remedy by a private channel and not by public courts. So how can restrictions that are imposed on courts be applied by the parties or be applied by the arbitrator in an arbitration? Third thing is that Arbitration Act is a complete quad. So why should CPC be applied to something that is self-sufficient? Now, this is a very critical judgment because it in the end says that the only sole factor that is to be considered is whether a particular granting of a particular injunction will be the interest of justice or not. But the question then arises is, how do you determine whether it is in the interest of justice? If there are no factors to be decided, the discretion that may be exercised by the arbitrators will become arbitrary. And precisely because of this reason, the inclusive approach evolved. Now, there were other few judgments where the Bombay High Court has also taken a slightly divergent view, saying that no doubt the arbitrator is not bound by the rigors of CPC, but it has to apply principles and ultimate test will be in the interest of justice. So if you see that there is a tendency that these two particular aspects, exclusive approach and inclusive approach, have merged together, right? And now the principle is that yes, the court has to apply the bare principles of CPC under Order 39 Rule 1 and 2, or if supposedly, usually what happens is if the defendant is trying to dispose of the property or if he is trying to sell off the property, in that case, an application can also be made under Order 38 Rule 5, that is to secure the party, wherein the defendant can be asked to furnish securities in order to protect the property. Supposedly, let's take a simple example. There's a contract, right? The contract provides a sale of a particular land, or performance of some work on a particular land. Now, the consideration that is promised is 5 crores. There is a termination of the contract. I am in loss. My loss is 3 crores. Then the court can say that, see, you may dispose of that property, right? Or you may dispose of the structures that have been fixed on that property. So, in order to protect this person who has suffered a loss of 3 crores, you give me a undertaking, or you give me security in the form of bank guarantee so that he can be protected, right? So, such type of thing can only be done when you show that the other person is trying to dispose of that particular property, or he is trying to, or if such type of interim relief is not given to me, then irreparable loss will be caused to me, right? So the court has now made it very clear that as far as the specific requirements that are required under Order 38 Rule 5 or Order 39 Rule 1 and 2, even if a party is not fulfilling one of the particular ingredients, but it seems to be in the interest of justice, then the court can grant interim reliefs on the fulfillment of those particular conditions. Now, this has been said by the Supreme Court also in Adhunik Steel Limited versus Orissa Manganese and Minerals, which is a 2007 case, as well as Nimbus Communications Limited versus Board of Control for Cricket in India and others. In these two cases, the courts have clearly stated that the grant of relief under Section 9 cannot be independent of the principles of CPC, but principles of CPC will be applied and can be molded by the judge to the extent of securing the interest of justice and the right of the parties. That is now the law at present. Now, there's a new principle that has emerged. It's very recent in 2020. Principle of emergent necessity. Now, the name of the judgment is Avant Holding Limited versus Vitstra ITCL India Limited. And what happened is that the court said that, see, after the amendment that has happened to Section 17 of the Arbitration Act, the court as well as the arbitrator under Section 9 and Section 17 respectively have the same amount of power, right? So, if arbitrator as well as the court has same amount of power, why should then the court grant relief? Why shouldn't it be the arbitrator who can grant such reliefs? On this, the court said that first thing, that it will amount to forum shopping and it will amount to misuse if the courts under Section 9 grants the same reliefs that the arbitral tribunal can grant. Therefore, the court said that now, if a person wants to approach under Section 9, not only he has to show prima facie case, irreparable loss, and balance of convenience, but he also has to show as to why he needs the relief so immediately and why he cannot await for the constitution of the arbitral tribunal and for the arbitral tribunal to decide his application under Section 17. So the court has added a fourth condition now, and this is in light of the similar powers that now can be exercised by the arbitrator, which is very similar to that of the courts, right? So this is the last ingredient which has now been added by the courts when they grant a interim relief. Next slide, please. Now, this is an important aspect. Can courts grant interim relief on an unstamped arbitration agreement? Now, if you recall, in Garwale Walls Ropes Limited, which is a Supreme Court judgment, I think it is by Justice Rohinton, but I'm not sure, wherein the issue was whether an arbitrator can be appointed under Section 11 when it is shown by the party that particular contract that they are relying upon or particular arbitration agreement that they are relying upon is unstamped. The court said that if a document is unstamped, it will be impounded by the authority and no arbitrator can be appointed. Now, the question was whether this particular principle will also apply to Section 9 application, which is for interim relief. Now, if you read para 30 very closely of Garware Wall Ropes Limited, you will find that there were two questions framed by the court. First was whether an arbitrator can be appointed under Section 11 if the arbitration agreement is unstamped. And second question was whether an interim relief can be granted under Section 9 when the arbitration agreement is unstamped. Now, on the first question, the Supreme Court has given elaborate answers to it. Various observations have been made, and ultimately, the Supreme Court concluded that no arbitrator can be appointed. But in the second aspect, the court has given no answer at all. The court merely writes one line towards the end that as far as the answer to question 1, as far as the findings on question 1 by the High Court is bad in law and against the proposition of law as established by the Supreme Court. But it does not say anything for the second question, that is regarding Section 9. Taking this gap into the findings of the Supreme Court in this regard, in Gotham Landscapes Private Limited, which is a case after that Garware Walls Rope Limited judgment, the court said that, see, you have to appreciate the difference between the remedy that is available under Section 9 and the right that is exercised under Section 11. Section 11 is for arbitration, for appointment of arbitrator. And as soon as the arbitrator is appointed, the arbitration comes into motion. But Section 9, on the other hand, is to protect the property till the arbitration is commenced. And precisely because of this reason, as Section 9 is there to protect a particular property, courts can grant relief under Section 9 even if the document is unstamped. Now let's take it from in a very practical manner, in a practical approach to understand this. Supposedly there is a particular agreement, right? Now the agreement is unstamped and you go to Section 9 courts. The court says that no, we are going to impound it, no interim relief to you. By the time the other party sells off that particular property. Now, as far as stamping issue or insufficiency of stamp is concerned, you could have easily paid the deficit stamp duty, and after paying the deficit stamp duty to the collector, the agreement could have been stamped and it could have been become enforceable under law. But by the time you do that, the whole thing, your property is gone. So in order to stop such type of absurdities, the court said that Section 9 can be granted even though the arbitration agreement is unstamped. However, to this I must also point out a caveat to you. This particular judgment of the Bombay High Court has been challenged before the Supreme Court, and the effect of this order has been stayed for the time being, but we will see in the future how the Supreme Court decides it. There's another judgment also by the Bombay High Court itself, that is Saifi Developers Private Limited. Same issue was involved, and the court reaffirmed that under Section 9, interim reliefs can be granted despite the arbitration agreement being unstamped. Right? Now, where to approach in case of foreign awards? That was the question in Temco. Now, in Temco, what happened? The Bombay High Court, for the purpose of Section 9 of the Act, held that for the purpose of Section 9 of the Act, held that once a foreign award is passed, the court of the jurisdiction would have to determine on the basis of the definition of the court provided under proviso to Section 47 of the Act. Now, if you recall, this Section 2 subclause 1E of the Part 1 of the Arbitration Act defines what is a court. Right? Now, under that definition, the court is usually the court which is fixed by the parties, means if it is read with Section 7, seat of arbitration, then that particular court will be the court. But the court said that no. Under section 47 proviso, the court which will have the court which will have subject matter jurisdiction, that will be the court where you can file section 9 when you are filing your award for enforcement under section 47. So when you have your award in hand, you want to enforce it, but enforcement may take time. So in the meanwhile, you can also ask for section 9 reliefs. Before which court? Before the court which has subject matter jurisdiction, meaning thereby where the cause of action has arisen. Right? Then the third thing is award by an emergency arbitrator. Now this is an interesting discussion, and I'll tell you why. See, under the Arbitration Act, if you see the whole scheme, Section 9 provides for interim reliefs even before the arbitral proceeding commences, right? That is for the purpose that before the arbitration proceeding starts, at least the property is secure. Now, a new concepts have developed in various other countries and also in the arbitration centers that are in India, that before the arbitral tribunal is constituted, the parties can appoint an emergency arbitrator. Emergency arbitrator will be any arbitrator that is selected by them, right? By the center, and that arbitrator will decide measures which are interim in nature for the parties, and his award will be binding only till the time when the main arbitral tribunal is appointed. Because in the appointment of the main arbitral tribunal, if you see, the consent of both parties are required, right? One part, like supposedly it's a one member arbitral tribunal, then I'll send my name, the other party has to accept it, and then only an arbitrator can be appointed. Second scenario can be that in a three-member arbitral tribunal, that I appoint an arbitrator, the other side appoints an arbitrator, and both appoint the third arbitrator. It's going to take time. Precisely because of this reason, new concepts have evolved of emergency arbitrator, which is now prevalent in CIAC, Mumbai arbitration rules, even Delhi foreign arbitration center rules provides for the same thing. However, there is some form of unclarity as to whether such a award that is passed by the emergency arbitrator can be enforced or not. Because award is a final adjudication, and this is not in a form of award per se, it's an order that is passed, which is of interim nature, though it is termed as award, but it is an order that is passed in form of interim relief, right? So what the courts have held is, now there is a split in judgments in this regard. Number one, I must again tell you that from the scheme of the act, it seems that emergency arbitrator is not per se recognized. But as I have told you, that if the parties are willing to go for emergency arbitrators, and if they have consented to such rules, such procedural rules which provides for appointment of emergency arbitrator, then they are bound by it. Whatever award is being passed, or sorry, whatever order is being passed. But as far as the legal position in India is concerned, it's not very quite clear. And I think either judgment of the court will clarify it, or it may require an amendment of the act, which I am unsure of. But for the time being, there are three cases which have been decided in this regard. In Raffles Design and HSBC, what happened is that an emergency award was given by the arbitrator in a foreign arbitration, means the seat was outside India. The award was given, now it was to be enforced. Then they filed a section 9 and they asked for the same reliefs. A question came that when you have already gone to emergency arbitrators for interim relief and it has been granted to you therein, how can you claim reliefs under section 9? The court said that no, they can claim, but the court will not be bound under section 9. The court will not be bound by the emergency arbitrators award. For the purposes of section 9, the court will decide on itself whether the ingredients or the tests that are applied to section 9 are fulfilled or not. Right? Now, in Ashwin Midha case, this is a Delhi High Court judgment. It is much more interesting as compared to the other two, because it gives a different opinion and also distinguishes the other two cases. What happened in this case is that there was an emergency arbitration initiated by the parties outside India. It was also a case of foreign award, foreign arbitration. And the emergency arbitration was initiated. The arbitrator declined from granting a interim relief. He did not grant an interim relief at all. Now, these parties, one of the parties filed a Section 9 petition in India saying, uh, disclosing the facts that there was an emergency arbitration outside India, and now it is required that this court be willing to grant a Section 9 relief. The court said that once you have been denied interim injunction by your arbitrator in emergency arbitrations, after being denied there, how can you approach the court? The court said that by your very conduct of submitting the disputes to that emergency arbitrator, you have excluded the application of Part 1 of the Arbitration Act. Now, as I have told you, there is implied exclusion, express exclusion. The courts have made it clear that Section 2 sub clause 2 can only be made by express exclusion, right? So in this case, the court said that you have excluded the application of Part 1. You can't come under Section 9 once you have been denied relief under or by the emergency arbitrator. But that's not the point. The point is one observation made by the court. The observation that when you have submitted your dispute to emergency arbitrator, can you file a Section 9 also? That's the point. Because in Raffles as well as HSBC, the court says that you can proceed for interim reliefs before the emergency arbitrator, but proceeding before the emergency arbitrator would not mean that your rights under Section 9 are excluded, because the Part 1 of the Arbitration Act is expressly excluded by the parties. Until and unless there is an express exclusion under the agreement, it cannot be said that you have excluded the application of Part 1 of the Act. But in Ashwin, the court said that no, as soon as you have gone for emergency arbitration, Section 9 in India is excluded. So this is a small confusion, and I think the Supreme Court may try to clarify this position, because two separate and distinct opinions have been taken by two courts. One is by the Bombay High Court and one is by the Delhi High Court. Let's see what happens in the future in this regard. Next slide, please. Now, as we have covered Section 9, now we will come to Section 17. As you can see, Section 17, you can make an application before the arbitral tribunal during the arbitral proceeding at any time after the arbitral award is given, but before it is enforced in accordance with Section 36 of the Act, apply to the tribunal for the following these reliefs. Now, this is very similar to Section 9. We need not to discuss it again, because I have told you earlier what are the form of reliefs that can be given. Same reliefs can be given under Section 17, but there are few modifications, and that we will discuss in the next slide. Can you go to the next slide, please? Right. So the first thing is whether the arbitral tribunal has to apply the CPC. Same question arose in the context of, Same question arose in the context of Section 9. The similar approach was taken for this also. In Yusuf Khan, Bombay High Court judgment, the court said that principles of CPC will also apply to arbitrator, but they have flexibility. The flexibility is that they have to exercise in the interest of the parties, as well as what serves the interest of justice. That same approach has been taken by the Delhi High Court in Natrip and Shailendra, which we not to discuss, because we have discussed these particular principles earlier. The courts have said that arbitral tribunals have flexibility. They have to apply these principles and mold these principles in a manner which best suits the case before them, right? But the basic principles will apply. That is what the courts have made it clear. Power of contempt. Now, this is important. Because earlier, if you remember, before Act 3 of 2016, which amended Section 17 also in 2015, there was no power of contempt of the arbitral tribunal. What the arbitral tribunal had to do was that if the order was violated, then it had to submit under Section 25, subclause 5, I guess, to that particular high court. And then the high court could have initiated contempt. And that was also restricted during the proceedings, right? Now, this was felt, and as you know, that model law Article 17 also provides that states have to ensure that the award or a order passed by the arbitral tribunal is binding and it is enforced. It is precisely because of this reason that Section 17 now provides that the order of the arbitral tribunal will be enforced in the same manner as the order of the civil court. So, therefore, if any person violates the order of the civil court, you can initiate a contempt proceeding. In the similar fashion, you can also initiate a contempt proceeding if an order is passed by the arbitrators. Same reliefs will go. If you read Order 39, Rule 3A, I remember that there are certain safeguards that are provided. For example, civil prison and all these things are provided therein, which now can be exercised by both, right? So the last, now the question is right against third parties. Now this is very important. See, as far this is actually something which is unclear, because when Section 9 and Section 17 are similarly worded, it seems that the arbitrator, in some specific facts and situations wherein the third party is trying to make the award a paper decree, or is trying to make the interim order that is passed a paper order. In order to avoid such situations, I think the arbitrator should also be allowed to pass interim injunction against third parties. That's what my feeling is. But as of now, what the case law shows is that a court under Section 9 can pass interim orders against a third party, but arbitral tribunal or an arbitrator cannot pass orders against third parties. But let's see, this may be subject to change, because all these judgments, specifically if you see 2009 and 2004, are before the 2015 amendment, right? As far as 2016 is concerned, this is a Bombay High Court judgment which has relied upon the Supreme Court judgment of 2004 extensively. So it's unclear as of now, but we will see in the future whether there is a change in respect of Section 17 or not. Next slide, please. Here we come to an end of our discussion today. So thank you so much. I am open to questions now. You can ask.
So the first question is whether interim relief under Section 9 can be given by the commercial court.
Commercial court?
Yes,
Yeah.
sir.
So see, Section 9, because it's a commercial dispute now, is filed before the commercial court. There's no problem.
Okay. So the second question is whether court can order for arrest of the party and detention in civil prison under Section 9 of the Act.
Yes. If the party commits a contempt, disobedience of the order, it will amount to contempt and can be sent to civil prison.
Okay, sir. Thank you. The next question is whether Section 9 is applicable in foreign seated arbitration. Sir, though we have discussed this, but if you want to add some more points to this question.
Yeah, Section 9 will apply to even to foreign seated arbitration. There's a recent Bombay High Court judgment on this as well, wherein the court says that if a party, the issue there was where should a Section 9 be filed. The courts have stated it clearly that where you seek enforcement of the award, there you can file a Section 9 also for interim protection of the property before the award is enforced. That is what the courts have said.
Okay, sir. So the next question is emergency arbitration is suitable substitute under Section 9?
Is emergency arbitrations substitute to Section 9.
Yes.
Okay, so see, emergency arbitration is a very good concept, and I am in favor of it. There are various countries that have now provided for emergency arbitration. Even the UK Act, the UK Arbitration Act provides for the same. The CIAC rules, ICC rules provides for emergency arbitration. The Bombay Center of Arbitration, as well as the Delhi Foreign Arbitration Center, also provides for emergency arbitrators and arbitrations. So I think that this is something that now the legislature should expressly provide. And it should be a very good substitute for Section 9, because then there would be no requirement of approaching the court under Section 9, and people can easily refer their disputes to emergency arbitration. And I feel emergency arbitration should not only be applied to foreign awards, but it should be also applicable in domestic ones, because I think it will be much better scenario,
Okay.
especially in institutional arbitrations. And
So
yeah,
there's
there is
something in the
one
chat
other.
box just with this point.
Yeah, this is a
Uh,
Bharat Pandey has asked, Bharat Pandey has rightly pointed out that emergency arbitration was one of the aspects that was pointed out by the Law Commission report, but it was rejected by the Parliament. Now, I may just point out one Supreme Court judgment that is given by Justice Pointed. I can't recollect the facts of the case, but the principle I remember, and you will find it if you do a Google search, that if something is uh, proposed by the Law Commission or by a parliamentary body, and it is not accepted by the Parliament, it won't affect the interpretation of that provision. Meaning that if the Parliament has not rejected it, but from the bare reading of that particular section, it seems that what was proposed to be added can very well be interpreted into it. In such a case, the mere fact of rejection by the Parliament will not be a conclusive proof that something was rejected as a concept altogether. So that's what I think. It's a judgment of Justice Roynton. Tomorrow, if I also have a session tomorrow I'll be able to point out that judgment. But let's see. For the time being, that is my answer. And I think
okay, sir. So the
you,
last,
okay, one more thing I wanted to add. You should also appreciate that there's a Centro Trade. There was a judgment by the name of Centro Trade. I think it was given by Justice D.Y. Chandrachud, wherein he said that even if the multi-tier arbitration system or the appellate arbitration system is not provided under the Arbitration Act, if the parties have agreed for it, the consent of the parties or the agreement of the parties is supreme, because it leads to the constitution of the arbitral tribunal. The whole process of arbitration is dependent upon the arbitration agreement. And if the parties have agreed for multi-tier arbitration, meaning thereby that first there's arbitration, then there's appellate arbitration, which is though not provided under the Arbitration Act, still the parties can go for it. There's no problem, because there's no restriction under the Arbitration Act for such type of scenario. Merely because the Arbitration Act does not provide for it does not mean that it stops it as well. I think the same principle can be applied in context of emergency arbitration. That's my response for now, but let's see what happens in the future if a case is decided in this fashion.
okay, sir. Thank you. The next question is, with respect to the point that arbitration clause will stand even the agreement is void, except in case of void ab initio. So with this, what will be its applicability of competence and Indian perspective with respect to the jurisdiction if main agreement is void?
Now, this is a question that can I discuss tomorrow, because tomorrow I'll be dealing with Section 11, and I'll be dealing with the aspect of existence of the
Okay,
arbitration.
sir.
And that time it will be very relevant, and I'll be able to tell you and buttress the things with case laws. Don't worry.
Okay, sir. Sir, there is one question in the chat box.
Just give me a second. Let me open it. Okay,
Okay,
reference design international.
something pointed out by someone. So, sir, thank you.
Okay.
Yes, sir.
Yeah, you are right. Who is this Anubhav Mishra? He is pointing out the right thing. It was raised, and that. But see, what the Bombay High Court ultimately did is that it recognized the emergency arbitrator's order, but said that, see, I will have to pass an order under Section 9. I'm not bound by the emergency arbitrations order. So I think emergency arbitrators order can only be used as a evidence, right? As an order which will somewhat assist the judge in writing an order under Section 9, right? But let's see what happens in the future. And to be honest, I feel that the legislature should amend it, and emergency arbitration should now become a part of the Indian Arbitration Act, because it will be consistent with the international practice. Any other thing?
No, sir. Thank you so much, sir, for your insightful views. I am sure that the participants would have thoroughly enjoyed and would have gained valuable insights from this lecture. Thank you so much, sir.
I hope so. Thank you.